Good morning and welcome to the Kansas Supreme Court. We have one case on the docket today. Larry T. Solomon, Chief Judge, 30th Judicial District of the State of Kansas as appellee versus the State of Kansas as appellant. Will counsel please state their appearances?
The appellant, Steve McAllister, and with me are Dwight Carswell and Jeff Cheney.
May it please the court, your honor, counsel, the appellee, the Honorable Larry Solomon, Chief of the 30th Judicial District, appears in person with counsel Elizabeth Herbert, Ms. Kate Berry from the Brandon Center for Justice, and myself, we're ready to proceed.
Counsel?
May it please the court, with the court's permission, I would request 5 minutes for rebuttal.
5 minutes, thank you.
All right. May it please the court, the district court's decision should be reversed for 2 reasons. First, the case does not present a justiciable controversy because Chief Justice Solomon lacks standing and the matter is not yet ripe for review. Second, the district court is incorrect on the merits. And that's for several reasons, but in deciding that question, the court should give the statute a presumption of constitutionality. The burden is on the plaintiff to show that it is clearly unconstitutional, and the applicable test is the 4 factors for separation of powers issues that are identified in a number of this court's decisions, including cases like Morrison versus Sebelius. And that's where I'd like to start, is addressing those 4 factors. Although I'm happy to talk about standing and ripeness if the court wants to.
I'd like to talk about the test. You mentioned the 4-factor test, and it's my understanding that that's the separation of powers test. Don't we have an entirely separate issue over just the language of the Constitution itself? Isn't separation of powers a totally different analysis from what does the language of the Constitution say? And what was the historical basis for that? And what kinds of modern exigencies do we have that might govern our interpretation of it? Aren't they 2 different lines of analysis?
Well, they could be, Your Honor, although I think the first factor under the separation of powers analysis is what power is being exercised. And in the state's view, that is basically conclusive here because of the constitutional provisions that exist.
But they're independent. They are independent analyses. So either way, you can win or lose.
I'm sure that's true.
Okay.
But, starting with the first factor.
Well, before we do that, let me follow up, because it seems to me this case is a lot like the old Peabody case involving the State Board of Education. And if you look at the language that's in Article 3 about the Supreme Court's having general administrative authority, that seems to be a self-executing provision. Would you agree with that? Just like the Article 6 provision was for the State Board of Education.
To the extent we were talking about what is general administrative authority, I think that's one of the real questions here, Your Honor.
And so that would take us, which I think is where we're pointing a little bit, that would seem to take us to the language of Peabody that says we look at what the legislature did to see whether it's in harmony with that language or in derogation of that language, correct?
That's correct, and we certainly can go that route if that's what the court chooses, because again, the constitutional provisions, and of course you have to construe Article 3, Section 1, and as well as looking at all other constitutional provisions that are relevant at the same time, and there are several. Let me start, though, with Article 3, Section 1. Of course, that sentence about general administrative authority was added in 1972. Professor Heller, I have his book. He's written the only book on the Kansas Constitution, describes that amendment as the major advantage promised by that amendment was that this court could control district court resources in the sense of assigning judges where they were needed most. Some districts had very low caseloads, some had much greater caseloads. That's the way he describes this. And that certainly is consistent with the language. The other provisions that come into play would be Article 15, Section 1, which began from the very first Constitution. That provision says if officers positions are not provided for otherwise, then the legislature basically can provide by law how they shall be appointed. That is,
Counsel, is an officer the same thing as a judicial officer? Aren't there references to judges about judicial officers rather than officers, plain
well,
officers?
I mean, Your Honor, with all respect, I'd say they're executive officers, they're legislative officers, they're judicial officers, but they're all officers constitutionally. And certainly the U.S. Constitution does not make any distinction when we talk about principal and inferior officers. That includes judges and others.
Is there a place in the Constitution where the drafters are specifically referencing judges, where they call them something other than judicial officers, as opposed to officers only? Is there a place that specifically references judges?
The Article 4, Section 3, it's about recall, and that provision says that public officials are subject to recall except judicial officers.
That's what I'm saying, though. The reference to judges in that provision is to judicial officers, the entire phrase, not
Well,
just
then,
officers.
you could look at Article 3, Section 2, which talks about this court, and it designates how the Chief Justice is selected, but says any justice can decline to accept that office or resign from that office, and it doesn't say judicial office, it just says office.
Is that the only one you've got for me?
I think that's the only one
Okay.
that uses
Thank you.
office. But what I was,
Well, under your view, making the reference to officers, under your view of the Constitution, could the legislature change the method of selection for the judicial administrator?
potentially, I guess there are two questions there, but if the method is not otherwise provided for, and I don't believe it is in the Constitution, that would mean Article 15, Section 1, as well as Article 2, Section 18 would apply. But then the question, I think, Your Honor, would come back to Article 3, Section 1, what is meant by the general administrative authority of this court? So in that sense, that may be the critical question. What is administrative authority, and exactly what does that cover here?
For example, if we were trying to decide how to extend your rationale, and let's extend it to the judicial administrator, one of the things we'd have to look at, wouldn't we, is what job duties are assigned to that office. Isn't that correct?
You would, but I think also the question I think there'd be a very strong argument that the judicial administrator is not an office per se as the Constitution contemplates. What it seems to contemplate, I think, are things like secretary level executive officials, the judges themselves. The legislators would be officers, but I'm not sure it's contemplating all staff that would be underneath those people.
Then how would a chief judge fall under that? I mean, there's no provision in the Constitution for a chief judge.
No,
it's an administrative function.
Well,
Seems like the judicial administrator is also an administrative function. So why wouldn't those two equate?
I would agree that chief judges have administrative functions, but they are also creatures of statute that the legislature created.
So is the
Presumably-
judicial administrator.
Okay, so if the legislature's created it, then I guess the answer would be yes, they can determine how that position is appointed.
I'm confused. Where are we looking for our definition of officer? I thought before you were looking at the Constitution, now are we looking at statute and Constitution?
Well, because under Article 2, Section 18, and under Article 15, Section 1, it says if positions are not otherwise provided for under the Constitution, then they shall be appointed basically as prescribed by law. That gives the legislature the ability to both create offices and decide how those offices are filled. Otherwise, Court of Appeals judges are not officers under that, if that's the way we go. But there was no Court of Appeals. The legislature created it. The legislature can decide how the Court of Appeals is appointed. It can't do that for this court because it's in the Constitution. Same thing for district judges. But chief district judges are not in the Constitution. And as the judge below recognized, the Article 3, Section 2 provision suggests that a chief position is in itself an office.
Well, along those lines, let me ask about our case law tests, or essentially the common law characteristics of a public officer. And some of them appear to me to be met in this case. A salary is paid, the chief judge exercises the authority of the sovereign. But there's a couple key characteristics that our case law talks about, which aren't met. Namely, there's no oath of office and there's no term. And those have typically been held to be key characteristics before you can have a public office.
Well-
So how do you sort of establish a public office without all of the traditional characteristics of an office?
Well, Your Honor, I think in the judicial context, you can look at the constitutional provision, Article 3, Section 2 again, that treats the Chief Justice as an office. There's no term on that. And so in that sense, it's directly analogous.
But we don't need to look to our case law or common law because it's in the Constitution, right? So,
That's-
but here it's not. So where else should we look other than our traditional sort of black letter law definition of a public officer? Is there anywhere else we should look?
Well, not that I can point you to specifically. Again, I'd come back though to things like Article 4, Section 3, which recognizes judicial officers without specifying that's Supreme Court justices, that's district judges. That's certainly broad enough to include officers within the judiciary. And again, if you focus on those provisions, if the office is not otherwise specified, and the chief judge is not. I mean, the legislature created this. There were no chief district
Right.
judges.
Let me approach the question a different way, if I can. Assume with me that there are no chief judges. That's not a position that exists. And the Supreme Court, in the exercise of its administrative authority, calls up a district judge and says, I've got some administrative tasks I want you to perform. Is it within the scope of that district judge's duties as a district judge to perform those tasks?
Well, there's nothing legally that would preclude the district judge from doing that. Certainly, if this court directed and the district judge was willing to, but there's really nothing in the Constitution that would require the district judge to do that, whereas the chief judge position is created specifically to perform those functions.
So those administrative tasks are not inherent in the office of district judge. That's your argument.
No, they're not. Just like the chief justice's administrative tasks are not really inherent in the job of the justices of this court. I mean, this court itself has distinguished between two kinds of judicial roles. The essential judicial function, which is not an issue here in our view, and then the administrative part of it that Article 3, Section 1 recognizes. The court does have administrative authority, but the real question here is, what is that administrative authority? And so that's why I think we may get to, I guess you can come at it either way. You could say this is not within the court's administrative authority, in which case it's not a separation of powers analysis at all. But if it is, the other question is that an exclusive administrative authority? The governor has supreme executive power, but Article 3, Section 1 does not say the court has exclusive administrative authority. It says it has general.
So you're reading
administrative.
supreme to mean exclusive? Because that was one of the questions I wanted to follow up with a moment ago when you mentioned cabinet level officers. Can the legislature pass a statute that says it gets to, or not it, but that the employees of the Department of Administration, or let's pick Department of Transportation, get to choose the secretary?
It could. I mean, those are.
They obviously can. I mean, in
But
terms
I
of
mean,
can and may.
constitutionally, they could. Their offices. I mean, they
That's
can.
consistent with the governor's supreme authority?
It is, because it's not viewed. All I'm saying is the language in terms of his power is stronger than it is with respect to the court's power. And yes, it's long been the case that the legislature can decide certain positions have to be confirmed by the Senate, for example. And that is not viewed as an unlawful intrusion on the governor's supreme executive power. And I'm suggesting this court's general administrative authority is not worded as strongly as the executive
understand.
power.
But in your view, under the language that affects the governor's power, the legislature could constitutionally pass a statute where the employees of the Department of Transportation elect the Secretary of Transportation.
I think
And the
it
governor
could
had no role.
constitutionally. I think it could. I doubt that it would, but I think it could constitutionally, because that secretary position is an office not otherwise provided in the Constitution. And again, those two provisions say the legislature can decide how such positions are filled.
I wouldn't have asked this, but you said you don't think they would. Why not? They did this. Why wouldn't they?
Well, I think there's a difference here in that the purposes, as I understand it, behind the law would be to have greater local control with
I
the
want to talk
district
to the
courts.
purposes for a moment. I understand what your brief's position is. It sounded like at least the argument on practicality about Johnson and Sedgwick counties having a de facto system was entirely dependent upon the testimony of former Judge Eric Yost. Is that correct? That's the factual predicate for that, isn't
He
it?
certainly provided testimony, and I believe there was one other.
There were some other judges. There were 3 other judges
Right.
from Sedgwick County. And my recollection is they didn't speak to any kind of de facto system in either county. But if they did, those 2 very brief testimonies would be the entire factual predicate for how this process has worked in those 2 counties. Is that correct?
In the record, yes, I think that's correct.
Okay. So obviously, whatever those judges were able to say about that was limited by the extent of their personal knowledge.
I'm sure that's true.
Okay.
I'm sure that's true.
So if there are facts that are contrary to what those judges talked about, that are just maybe outside their personal knowledge, that's something that might have an effect on the decision on practicality.
It might, although if you want to talk about practicality, I would emphasize that several of our neighbor states use precisely this system and have for a long time. Nebraska, Oklahoma, and Missouri, and they all have constitutional provisions virtually identical, certainly in substance, to Article 3, Section 1. And no one in those states has viewed that as an unconstitutional enactment by those legislatures.
We don't have any evidence that that's ever been challenged. We know what's on the books, right? There's no actual factual, there's no evidence in the record about how that has proceeded or how well or how
I
poorly
think
it's
there is
worked.
evidence in the legislative history record of those practices in other states. That was certainly
That's
something.
what I'm saying. We have the statute. We have what's on the books.
Right, we have that, and,
Okay.
and no cases of which anyone is aware. And again, I would also emphasize, it's not the same, but if you look at the federal system, Congress has provided how chief judges are selected.
Well,
The Supreme Court plays
wanna-
no role.
I want
in
to
the process.
continue a little bit more on the stated purposes. I have a couple of problems with that. First being that it seems a little contradictory to say you need local control over a statewide unified system. A little oxymoronic to me, but more importantly, it seems to me that this system actually gives less local control than exists right now, because it only utilizes district judges to elect. But the chief judge affects a lot more people than the fellow colleagues. There are magistrate judges, there are clerks of the district court, there are CSOs, there are court reporters. Typically, all of those people have an opportunity to have input into the chief judge through the departmental justice. Now that's taken away from them under this system. So it seems like to me that's less local control than now exists.
Well, respectfully, Your Honor, I would disagree. There's nothing that precludes them from going to the district judges who are going to vote, just like they can approach this court.
Except for the confidentiality.
Well, the district courts can certainly respect that. And again, there are state Supreme Courts that do select their chief justice by the justices deciding. I'm unaware that there's any notion that everyone who's affected by the Supreme Court has to have a voice in that process. That's not an uncommon thing, that the body itself picks its leader. That's what happens in school boards, that's what happens in city commissions, that's what happens in county commissions. It happens with the Kansas Corporation Commission. There are many instances of the body itself choosing its leader. So there's nothing exceptional about that notion. The other thing I'd like to emphasize here is that the legislature is not exercising judicial power, which is one of the factors under the separation of powers test. It is simply exercising its power to designate how officials may be appointed when they are not otherwise provided for under the Constitution.
Dean, I'm sorry to interrupt, but on that aspect, I'd like to go back to the practical application of the statute. We know how the chief judge is chosen, but how is the chief judge eliminated if he or she is not doing the job they're supposed to be doing?
Well, I think there's two ways, Your Honor. I think the district judges themselves could vote to select a different chief, but also this court retains the authority to remove chief judges for cause. That's still in the.
But that adds a layer that isn't existing under the old rule. under the
That's
Supreme
true,
Court.
that's true, but for cause.
And wouldn't that affect the administration, the efficient administration of the court system?
It might affect the administration, but I would not say that it does so in an unconstitutional fashion. I mean, if you compare to federal law, the president, many positions the president appoints, in fact, probably virtually all, except maybe the cabinet level secretaries, are subject to for-cause removal restrictions, and the Supreme Court has long said that's okay constitutionally. That does not violate the separation of powers.
So you're saying that if a chief judge was elected and was removed for cause, that he or she then couldn't be reelected by the same group of judges that elected him?
Well, I suppose they could reelect, but I think this court could just remove the chief again,
Well, that's
as long as the cause remains.
just the whole impact of this. I'm a departmental justice for a district that has 2 judges, and what if they both seek the position?
Well, then maybe they have to have a coin toss or something. I mean, I
No, I
realize
mean,
there could
that's
be-
why we're jokingly talking about that. But is that the mechanism? The ability for the Supreme Court to intervene in that situation and say this is going to be how we do it, or we are out of that process.
Or I
Selection
assume
process.
there's nothing that would preclude those two if they both want the position from saying, since we're each going to vote for ourselves, it's a tie. Let's ask the Supreme Court to choose one of us. I suppose that could be done in a situation where you simply cannot accomplish an election.
Before you sit down, can we get to your the standing argument that you make? In essence, what you're saying is that can the legislature or can they enact a statute that confers standing to bring a lawsuit that which is less than the requirements of the Kansas Constitution? Can the legislature do that?
No. I mean, I think
that's the question here.
Yeah, I think this
In
court.
declaratory judgment, we say there's a relaxed standard. What does that mean in terms of standing?
I don't really understand the notion because the court says that, but at the same time says there still have to be the constitutional minimum requirements. I suppose in a declaratory judgment, if there are prudential considerations that might otherwise bar it, maybe the court can ignore those prudential considerations, but the constitutional requirements of an injury, an actual injury, are not dispensed with simply because it's a declaratory judgment action, or then people could challenge all sorts of laws that they simply don't like by filing it as a declaratory judgment action and not some other kind of action.
Let's dovetail the selection questions with the standing. The statute actually provides that the procedure for the election shall be determined by the district court judges and adopted by district court rule. Obviously, that has to be done now or yesterday to be in place by January. And so that statute placed upon the chief judge additional duties, did it not? Because if there's going to be a district court rule, Judge Solomon has to be in charge of making certain that gets through under his duties.
That's probably true.
And so this law gave Judge Solomon additional duties he did not have before. Why isn't that sufficient to give him standing to challenge that law?
Well, I guess, but he's not complained about the fact that he has to promulgate a rule for the district court. He's complained about, I may not be chief
Well,
judge after January 1st.
Well, he has complained, and in fact, you cite to it about the uncertainty in the ends of the process. And isn't that exactly what Justice Johnson is talking about? We have a rule, we have a law, somebody has to figure out which one trumps the other. A chief judge is sitting there looking at it, they have a decision that from this court that appears to say a rule trumps a statute. How is a chief judge supposed to go forward with this process?
Well, I think the chief judge would go forward by implementing the statute and figuring out a system to elect, but again, the injury.
And ignore a decision of this court.
A decision that, with all due respect, is wrong, and
But
in
how
any
is the
event
chief,
says
but
dicta.
isn't that still binding on the chief judge? Until a court rules otherwise?
Not if it's dicta, it's not binding. And in our view, Mitchell is absolutely dicta, and it's not only dicta, but dicta that's wrong. That's for this court to determine the wrongness. I agree with you there, but in terms of whether it's dicta or not, a district court does not have to follow dicta.
But doesn't just the fact of the uncertainty and the confusion meet a declaratory judgment standard for someone who would be bound by the judgment going forward and implementing the law, which Chief Judge Solomon would have to do?
I think what's really being complained about is a change in procedure, which is a sort of, the notion is there's a harm because the procedures are changing. Now that is true in some instances. For example, those who have tenured positions and you say eliminate any due process protections, well, that may be standing then because those procedures are connected to a property interest or something they have. But this court can remove a chief justice at any time for any reason. There's nothing like tenure for chief district judges. So really the complaint is just there's a process change that might affect me at some point in the future. It may well not have any effect at all. And when a chief judge loses their position, we wouldn't argue then there's no injury due to the change. But prior to that, it's impossible to know whether there is or will be an injury.
I have a few more questions
Okay.
before you sit down. So I don't want to let you get away, but I don't want to interrupt my colleagues either. Is everybody else satisfied?
I've got
with
some
that?
too, so.
Okay,
I don't
okay.
care. What
Somebody-
seniority?
To you, I get to say get in line. Okay, alrighty, so I want to go back to this idea of dicta in Mitchell. It seems like in every single case that an appellate court faces, it needs to decide what the rubric is that's going to apply in order for it to decide the outcome. Would you agree with me on that?
Yes, I mean, I would hope so, that there's
Uh,
a standard
in
or a
theory,
test or
That's what
something
we
being
do,
applied,
right?
yes.
We say our standard of review is X, the legal rule is Y, and the outcome is Z, pretty much. That's the overall pattern,
Yes.
sometimes very briefly, sometimes at great length. Well, isn't that exactly what the Mitchell Court was doing? It was saying, how do we judge this matter? This is the rubric, and we've decided that this rubric dictates this outcome. So how does that make the discussion of what the rubric is dicta?
Well, in the sense that the facts did not actually present the issue.
Ultimately, the rubric dictated the outcome would be there was no conflict and therefore there was no problem.
Well,
But the rubric was needed in order to determine that you looked for conflict, wasn't it?
True, Justice Breyer, but I'm willing to let you have the proposition that it's not dicta because it's still wrong.
Okay,
on the
I
merits.
understand you have this second position on it, but I just wanted to focus on the dicta assertion.
Well, and dicta can be a tricky thing because there are
It
lots
can.
of things said in opinion. It's not always clear exactly how essential it is. And just yesterday, I was here arguing about whether something was dicta or not in one of this court's decisions. So I recognize the potential
It's a little like
confusion there.
beauty.
Pardon?
It's a little like beauty.
Yes, it is.
In the eye of the beholder. Okay. The court has found a bunch of other, you want to talk about other states, and the court has found a bunch of other cases from other states having to do with when they decided that some legislative enactment crossed the boundary of significant interference with the operations of the judicial branch. It appears from that research that of the 8 or 10 cases or whatever that were found, the majority have found that there was a conflict, and therefore unconstitutional encroachment. Just assume that with me for the moment. Tell me what I need to look for in those cases that will help me decide whether they should be persuasive.
Well, I think what you look for is not a per se rule. If there's a conflict between a court rule and some other provision of law, the court rule always prevails. What you need to look to is what's behind each of those, the law and the court rule, and whether the court rule falls within the exclusive authority of the court. So I could see at least two ways. One, the court's authority is not exclusive over a particular area, so it will have to interact in some way with perhaps legislative enactments, or a determination that the rule is just completely outside the court's authority. So if, for example, the reason I think Mitchell is wrong is you can pose some questions that it seems to me that just can't be the correct analysis. If the legislature were to basically, well, let's say this court decided to define something as a crime. well, could the legislature acquiesce in this court establishing crimes for Kansas? I don't think so. Even if the legislature didn't do anything, someone could sue and say this court does not have the power to create crimes. Same thing, I think, if the governor was told that you cannot appoint cabinet secretaries, your top level executive office, you simply cannot appoint them. They'll be appointed by the Supreme Court or by the legislature, and the governor says fine. I don't think that makes it constitutional. It would still be a separation of powers violation. So acquiescence really is not a very good
I
test.
think you're talking about something more than acquiescence in those situations. You're talking about invasion from the get-go.
But
And
I think
here
that's-
we definitely had some, what for many, many years was productive cross-the-street conversation about how this should work, which in the ideal world should happen all the time.
Sure.
Because what we really had here, if I've got the chronology right, hold on, bear with me for one moment. Is that the Supreme Court promulgated a rule in '66 having to do with assignment allocation in the district courts. Then in '68, the legislature codified on that subject. And then it went back and forth. '72, the constitutional amendment, statutory amendment, rule amendment, back and forth, but always in harmony. Always in harmony. And that's a completely different situation than kind of the parade of horribles I think the state's trotted out here, where the state, or the Supreme Court attempts to, for example, legislate the contour of a crime.
Well, but I think the parade of horribles to me shows why the test should be the Morrison versus Sebelius, the 4 factors. I'm quite content to accept that test as the test here, but not the acquiescence
to accept
test.
the Morrison case on the 4 factors for separation of powers, which is almost a penumbra-like aspect of constitutional law. I mean, the separation of powers appears nowhere in our Constitution explicitly. We all agree on that. It's integral and inherent and all of those words that have been applied to it, but it's not a specific constitutional provision. And here we have a specific constitutional provision in addition to whatever separation of powers arguments that exist, which I think is where you and I started at the beginning of this.
Right, so if I
Or-
came back to Article 3, Section 1, I do think you could first ask, what is the general administrative authority granted to the court? And if the court takes an action like creating a crime, that would be outside the general administrative authority. So you could either say the court lacked the power, or you could say it's trying to use the legislative function, which is a separation of powers problem. I can see both questions in play, but I think they ultimately point to the same kind of analysis at the end of the day. We're deciding what's judicial or administrative and what is not. But there is another layer, which is whether that legislative or the administrative authority of this court is exclusive or not, because it does not say that. And we've given a number of examples of the legislature passing statutes that have been around for a long time that certainly regulate the court's operations. And with the chief judge in particular, that position, I believe, could be abolished by the legislature. I mean, it's a statute that creates it. There's nothing in the Constitution that says the chief judge has to exist in a district court. So if the legislature were to repeal that statute, there wouldn't be chief judges. They wouldn't have to provide for extra salary for chief judges. I think legislatively, the greater power may well include the lesser here. They can create the office. They ought to have some say about how the office is filled if they want to.
Certainly, just in terms of looking at history, what has happened, it is apparent, at least to me, that the legislature has certainly taken on a role of defining via statute administrative aspects of the courts. There's a lot of examples of that, and you list them in your brief. My question is sort of asking you to put on your constitutional scholar hat a bit, and goes to Justice Byers' notion of harmony in the history of how this worked and cooperation, which typically are viewed, I think, as very positive things as the departments work together. However, there's been some, especially recently, some very interesting, generally concurring or dissenting opinions coming out of the United States Supreme Court that indicate, to me at least, that there's some skepticism or concern that too much harmony, too much cooperation can actually erode the separation of powers. And that, in fact, it's not a good thing, and that courts should be vigilant in policing those boundaries, even if it's against a sort of harmonious cooperation between the branches. What's your thoughts on that, and how does that apply to this
Well, I
case?
agree. I mean, I'm a believer in the separation of powers, and they're important, which is why I think our position, if I can just step back from it, our position would be use the four-factor test, or if this court first wants to construe, and maybe that's the first step, construe Article 3, Section 1, does the general administrative authority include this kind of thing or not? If it doesn't, then there's really no separation of powers issue. If it does, but that authority is not exclusive and the legislature has some ability to regulate, I would use the four-factor test, not the Mitchell acquiescence notion, because I think the acquiescence notion leads to what you were talking about, Justice Stegall, and that's what I think the Supreme Court justices are objecting to.
And but Mike, to push the question a little further, doesn't the Morrison test also potentially lead to that?
Well,
I mean, it sets up a very high bar for finding a separation of powers, and I understand that helps your client, that helps the state in this case, but my concern is that perhaps that Morrison test actually creates too high of a bar.
well, I don't think it does, Your Honor, because in particular, the first two factors, I think the notion of what kind of power is being exercised may in and of itself answer the question, unless the Constitution provides for non-exclusive authority in that particular regard. And the second one, the degree of control, also, those two are pretty important in the analysis, and I think they are something different than acquiescence, and they do help defend the boundaries. I mean, one thing the U.S. Supreme Court has said, it's rejected the notion of acquiescence really flat out. There are examples of cases, line item veto, other things where the court says, we don't care that Congress passed this and wanted to give this power to the president. The Constitution doesn't let the president exercise this power. Said the same thing in New York versus United States. We don't care that many states ask Congress for this particular law. It intrudes on state sovereignty, so it's a federalism rather than separation of powers, but it's the same idea that acquiescence just is not a good constitutional standard for a lot of reasons.
And that was part of what I was trying to get at, to get you to say there are two different lines of analysis we need to look at here. The one that's really dependent directly on constitutional language, and the one that has to do with the Morrison-Sebelius test.
Which I think you can approach it that way. Your Honor.
I have a couple more questions, and we've been kind of esoteric for a few minutes here. Appreciate your willingness to go there. Let's talk a little bit about brass tacks. I think both of the amici talk about the 2015 legislation, which all of us as lawyers can acknowledge is not directly at issue here. But it can perhaps speak to purpose and intention, which is a part of that four-part test. So I'd like you to address the amici on that point. The American College brief, as I recall, in essence makes kind of a constitutional imperi materia argument, analogizing to what we do sometimes in statutory interpretation and construction. I think the ACLU brief is a little bit different in focus, but I'd like you to respond to those two before you sit down.
Well, I would say the state's position would be that the 2015 legislation is irrelevant to the question before the court, and I would think of it in terms of the way legislative history is used, and subsequent legislative history is not. I mean, the Supreme Court has basically got U.S. Supreme Court out of the business of looking at subsequent legislative history. They look at the law at the time it was enacted, what was going on, because certainly by the time you have subsequent actions, you have some changes in personnel in the legislative body. Their reasons may have changed over time for why they're doing something, so I don't think you can take a later law to say this is exactly what their purpose was when they enacted the first law.
On that last point, did we have a change in personnel? Was it 2014 and 2015
We may
legislature?
not have.
Yeah, I don't think that applies here. But there are purposivists among the justices as well as originalists. Wouldn't you agree? So that sometimes go beyond originalists.
There are, although even the purposivists, we'll say
That's
that
a hard
word,
one to get out.
even it's kind of like justiciable, but even they, by and large, would say, I think that we are not typically inclined to look into legislature's motives. We may look at legislative history for what they intended the statute to do.
I understand that typically we might not, but this test asks specifically what was the intention? What
It
were the
asks,
goals? What were
although
the
as the
intentions?
district judge recognized here, and I think the parties agreed, it's the least important because it's really not a very satisfying or strong way to try to analyze. I mean, the court, I suppose, if that remains a factor, could actually say, well, this does not intrude on the other branch's power. This was the branch that acted within their power, but their purpose was to do something wrong. It would seem sort of backwards to then invalidate that law because there was a bad purpose. I think the stronger factors are the other three, and that's exactly what the district court said. It wasn't putting any real weight on the third factor, and I don't think this court should either. I recognize it's within the test.
Okay, thank you. I'm done now if you want to say something.
If I can
Go on,
go, I will just keep
There are a
moving
lot
down.
of people ahead of me in seniority, so I'll just wait my turn.
I would like to ask about what role function plays in this in terms of the function of the position of chief judge. We've focused a lot on that actual selection, but does that line smear when we look at what we're asking a chief judge to do? And if those tasks are basically general administrative tasks, what impact does it have on the court being able to use a mechanism of executing its general administrative tasks through an agent? And what role then does the court have as the principal in that relationship?
Well, Your Honor, first of all, I'd candidly acknowledge it would have some effect on this court's control, but not enough to be unconstitutional. And again, I would point to the other states around us that have their Court of Appeals, their districts select their chief judges. And Nebraska Supreme Court, to my knowledge, is not saying we can't administer the court system. The Missouri Supreme Court is not saying we can't administer the court system, nor is the Oklahoma Supreme Court.
Is that the test? Does there have to be a complete disruption of our power?
Well, I think it has to be a significant interference under this court's cases. So that's the way the court articulates it. It says we're really trying to decide if one branch is usurping the powers of another. The standard is whether that other branch's action is a significant interference with the other branch. And then the court typically has gone to the four factors that we've been talking about to decide what is a significant interference. So the practical impact is a factor, not a determinative one, but it is a factor.
So that necessarily has us looking at Section 2 of the legislation, which is the independent local budgeting provisions, correct?
Well, that's not been challenged in this action.
Yet, all parties in this case agree that under the Morrison-Sebelius test, one of the factors is significant interference. And so one of the things we have to look at is what function, you agreed with me on the same question earlier, we have to look at the function that the person performs. And that necessarily takes us to Section 2, doesn't it?
Well, I'd see it a little differently, Your Honor. I think that function analysis goes to whether it's an office or not, and whether it's separate, and if it is an office that is separate from being a district judge, then you're within Article 2, Section 18, and Article 15, Section 1. So I would look at it to that extent, but I do not think because your suggestion, I think, would lead to anything in that law that in any way impacts the chief judges or the district courts is now being challenged, and the plaintiff has never challenged anything but the selection provision.
Well, but the test you're using, I'm not trying to say that Section 2 is unconstitutional. I'm trying to say, which that argument might have been made, I think it was made in the dialogue. I'm trying to say that in the test over whether the selection thing
I'm with you there. So you're
works,
looking at
then
what...
you have to look at the function that
Agreed.
that individual performs, okay?
Agreed. Yes.
So given that, how does having 31 independently selected chief judges with the authority to have independent budgeting and control over their budget further a state unified court system?
Well, Your Honor, I don't think that's the question. I think the question is whether it's significant interference with whatever this court's general administrative authority is under Section 1. I'd say two things about that. One, in the bill itself, the court retains supervisory authority in many respects over the chief judges, has the power to remove them for cause. And I also, as I recall, the law gives the chief district judges the option, but not necessarily mandates that they control.
It's the authority to
Right.
be able to have an independent budget and to independently control the expenditure and the classification and the personnel within that district. And if you've got 31 independently selected chief judges who can run their own little fiefdom in their area, isn't that what the 1972 amendment did away with?
Well, Your Honor, I'm not sure it did, and I think that's why we're here today. If that were absolutely clear, then the state might not have any real argument to make. But again, if I go back to Professor Heller's book, says the major advantage promised by this was the ability to move judges around or give them assignments that would spread the judicial workload. It wasn't about this court picking the chief judges. That was not what they were talking about in 1972. And so the court remains a unified system in the sense that the 1972 amendment seemed to be primarily concerned with. This court still has the authority to assign district judges to sit in various places, including on this court. So that power has not changed. I will agree with you that in evaluating the fourth factor under the test, you would look at the duties and responsibilities. I mean, that is the practical part of the practical effect. But again, I come back to, I just am not convinced, the state's not convinced that Kansas is unique in this regard as opposed to Nebraska, Oklahoma, Missouri, or even the federal system.
Do Nebraska, Oklahoma, or Missouri give the individual chief judges of their districts the independent budget authority and control that we find in Section 2?
That I don't know, Your Honor.
Then we don't know that those are good comparisons, do we?
Well, I think they are in terms of they've not deemed the selection process. I mean, that's one factor. For all
But
we,
it depends on what authority you give the individual that's being selected.
well, and I would offer, Your Honor, if it would be helpful, I think the state could certainly look at that and submit, if we can find any authority on those other duties of chief judges in Missouri, Nebraska, and Oklahoma. But I do not know what their duties are, to be honest.
I'm trying to tie something in that you said earlier about the statutory creature, the chief judge is not mentioned in the Constitution. State legislature abolishes that position. You're not saying the Supreme Court then couldn't establish chief judges in each district, are you?
As long as it's part of the general administrative authority, I suppose it could, but I think that would be a question whether the court has the power to create those if they are offices, because the Constitution says if there are offices not otherwise provided for, the legislature has that power.
And assuming that then, would the legislature then, once that's been done, be able to tell the court how those chief judges are to be selected?
Well, again, if they're offices, I don't think
Yeah.
the court could do it in the first place. And if they're not offices, then I think we come back to the four-factor test if the legislature somehow tried to weigh in on how those people were selected.
So your argument is that Supreme Court Rule 107, which sets out the selection of chief judges, is really not properly promulgated.
Well, it's properly promulgated in terms of the court's procedures, but my real argument is that it now conflicts with the statute, and under the Constitution, the statute should prevail. I mean, there is a question of, how far can the court go in general administrative authority? So I guess there would be an argument even if the legislature, that's harder. I mean, the court didn't create the chief judges in 107. It simply provides for their appointment. And what I was suggesting is because the legislature could create the position, it could abolish the position, it should be able to say, here's how the position will be filled. So I'm not necessarily saying in the absence of anything else, Rule 107 is necessarily unconstitutional.
Under the old version of the statute, didn't the statute essentially say that the method of selection would be governed by Supreme Court rule?
Under the old
So
method,
Supreme Court Rule 107 originally, at least on the surface, derived its authority, if you will, from the statute.
from the statute, from the legislature, and if the legislature repeals that statute, which it did, then arguably that authority is gone.
Do you have any case law that upholds a piece of legislation that contradicts a Supreme Court rule? An existing Supreme Court rule?
Well, I don't know that the situation has ever come up.
I mean, it's yes or no. Do you have any case law?
No, because I'm not aware of ever, the U.S. Supreme Court's rules are by almost entirely procedural. They're about briefs and filing deadlines and various things. I don't think there's anything in there comparable to this. I mean, they certainly have no role in appointing people under a Supreme Court rule.
Well, but you've indicated that we can look to other states that have what you say are comparable constitutional provisions about general administrative authority. So if we look beyond the United States Supreme Court, do you have any case law to suggest that the legislature can overrule an existing Supreme Court rule?
I can point to at least one authority that says a Supreme Court rule is unconstitutional, and it was defeated in litigation. That's the Supreme Court of Virginia versus Consumers Union, a U.S. Supreme Court case where the court promulgated a rule that lawyers could not advertise, and that was struck down as a First Amendment violation. I do not have a case at hand where a statute basically said we disagree with the rule.
Can I clarify your position on severability? Is it it wasn't briefed in either of the briefs, but is section 43 of 2338 before us?
Well,
Because the statute before us has a non-severability portion to it. What is before us on that question?
well, I think the severability provision in 2338, yes, I think the parties agree that if the chief judge provision is unconstitutional, then the non-severability provision kicks in. That was certainly what the plaintiff argued below, and the state did not argue to the contrary, and the district judge decided when he ruled that it did.
It did. Okay.
It did
But as a
apply.
practical matter for us on appeal, no party is claiming that the district court erred in its analysis on the non-severability, so that issue is waived.
I mean, if you
That's
want to view it that way, we have not challenged that, yes. Any further questions? All right.
Thank you, counsel.
May it please the court. Before I commence my formal arguments to the court, I like to place on the record that a gentleman, an excellent lawyer that was supposed to be here with me today, unfortunately passed away a few weeks ago. His name was Randolph Sherman. Mr. Sherman was the chief of litigation at Case-Shiller, a New York firm that has provided invaluable assistance to our office in the development of this case. And it saddens me deeply that Mr. Sherman is not here today, but I think it is important for this court and the people of Kansas to know the immense contribution that on a pro bono basis, not only Mr. Sherman, but his firm have dedicated to the people of Kansas in this constitutional battle. I believe that this case presents simple questions for this court that need not be as complicated as the appellant makes them. First of all, how important is the administration of our judicial system to the Supreme Court? How seriously does the court take that duty? Because it is not your choice to administer, it is indeed your duty, mandated under Article 3, Section 1 of the Kansas Constitution. And what does that duty require you to do? Well, by the 1972 amendment, our court system was unified. And what counsel for the appellant is suggesting to you should be done would place us to a pre-1972.
Well, counsel, let me just interrupt you there, and I appreciate the admonition that these are simple questions. So in that vein, let me ask a few what I think are fairly simple questions. It's your position, as I understand it from your briefs and so on, that the position of chief judge is not a separate office, correct?
Correct.
And the chief judge is really exercising a portion for that chief judge's district, a portion of the duties, as you put it, of the Supreme Court's administrative role.
Correct.
Right? So if I could draw your attention to Section 13 of Article 3, how is it that chief judges are permitted to receive additional pay for doing something that is inherent in their duties as district court judges? Section 13 prohibits that.
I don't understand your question.
Well, you're familiar with Article 3, Section
Yes.
13,
Yes.
which prohibits any judge from receiving additional compensation for doing what he's supposed to do as a district court judge.
That is correct.
Yet our chief judges receive additional compensation, correct?
Correct.
It would seem to me that the only way a chief judge could receive additional compensation in a constitutional manner, consistent with Section 13, would be if the position of chief judge was actually a separate office. Because Section 13 also permits a judge to receive additional compensation if they are performing the functions of a separate office as provided by law.
I fully agree with that.
So help me resolve that contradiction.
Well, the chief judge is carrying out administrative duties for the court.
So he's unconstitutionally receiving additional compensation.
No.
We've got a big problem going back decades with chief judges being paid more, right?
Well, it's two separate issues. I don't believe that that is an appropriate analogy. The chief judge is receiving what is in fact a very small remuneration for performing the administrative duties assigned by this court. So I don't think...
and I appreciate that, but if we look at those facts, which I agree are correct, consistent with your position, but if we look at those in light of Section 13, wouldn't we have to conclude that those duties are something above and beyond, separate from the duties that are inherent in the position of district court judge? Because the Constitution is very clear that you can't get paid unless you're doing something that is additional. You're serving in an additional office.
I understand what you're saying, Justice Stegall, and there is no way to differentiate and argue otherwise.
Well, let me ask it this way. Does the position that Judge Solomon has taken and you're arguing now essentially force the conclusion that the additional pay for chief judges is likewise unconstitutional?
That's a very good question, and it's a question that I had not considered. Whether or not the additional pay to a chief judge of a district is in fact unconstitutional. It is not an issue that I had addressed. It is not an issue that I was prepared to argue before this court. And it may be. I simply do not know the
Fair
answer.
enough. I appreciate that. Along the same lines, let me ask a few other questions. In your view, consistent with the position you've taken, was it a violation of the separation of powers for the legislature to create the position of chief judge?
I don't believe so.
So distinguish for me why the legislature has the power to create the position of chief judge, but does not have the power to set the manner in which the chief judge is appointed. I mean, how can one be okay and one not be okay?
I think the answer to the question, Judge or Justice Stegall, is that one deals with the creation of the position, and certainly the legislature has the authority to do so. But as far as the manner in which that individual is selected, and the implications of that selection process, I believe that squarely falls
Okay,
within
so
Article 3,
you've just,
Section 1.
you've just told me that the legislature had the power to create the position of chief judge.
Yes.
So let me pose a hypothetical to you. What if this court, in the exercise of its administrative authority, decided our district court judges are overworked, maybe they're not very good administrators, so that's not a combo, but maybe we would decide that we want somebody whose job it is to be an administrator. They are trained for it, they receive, that's what they do. And so we don't think there should be chief judges. We think that there should be district level judicial administrators that we appoint. Could we, as a court, abolish the position of chief judge in the face of a statute that creates that position?
This is where the separation of powers and the intrusion from one branch into the other becomes critical. We have a system that for over 40 years has worked well, and we can certainly come up with a parade of horribles to determine now whether or not we should continue with a system that has worked so well for so many years. If the legislature decides to do away with the position of chief judge, it doesn't mean that by that decision, the duties of this court under Article 3, Section 1 to administer the courts is abolished. And it would place the court in a position to come up with a mechanism with which to do so.
Well, okay, so I'm just trying to understand your position, and what I'm hearing, correct me if I'm wrong, is that the legislature, as a matter of first instance, had the authority to create the position of chief judge, but should this court, in the exercise of its administrative authority, choose that that's not the best way to administer the courts, that in fact it would be better to have someone who's not a judge serve as a judicial administrator, that would then have to take precedent over the statute, maybe pursuant to Mitchell.
Well, that's a hypothetical.
Well, I understand,
It's
but
not a
it's-
question here, and that's not a hypothetical.
Well, it's my
answer.
question.
Well,
right?
I understand, Your Honor, but it hasn't happened in 40 years. The system has worked well. The point is, if for some reason the Supreme Court is not satisfied with the way a particular chief is taking care of his or her duties as chief, right now the Supreme Court under Rule 107 has the authority to do something about it. You can replace that individual without necessarily having to have cause. The system which 2338 sets in place takes that completely away from the court, creating what I believe to be a chaotic situation.
So, I appreciate that again, but let me just ask the same, but this is the last time I'll ask it, just very straight, yes or no question. Does this court have the authority to abolish the position of chief judge?
Again, Your Honor, I don't believe that the court has to make that decision at this time. Whether or not the court has the right to abolish a position, I think probably not. I don't believe that is the appropriate way with which to proceed, and I would not recommend that decision.
Mr. Gondegrai, your client won this case, based upon a summary judgment response to the motion to dismiss, as I understand it.
That is correct.
And then an affidavit was then attached to your motion for summary judgment that was not considered by the court because of potential discovery questions, and the court said, I'm not going to consider the affidavit.
That is correct, Judge.
So can you tell me what cognizable harm your client suffered based upon what is pled?
Yes, Your Honor.
What is it? Repeat it for me.
I'd be happy to do so. First of all, as Justice Johnson indicated in the questions earlier to the appellant, there has been additional duties imposed on Judge Solomon
Is that clear in the affidavit?
No, well, the affidavit was not considered.
Not the affidavit, I'm sorry, the pleadings. Is that clear in
The
the pleading?
pleading talks about the changes in circumstances, and it talks about the change in status and the effect that the bill has on the relationship that Judge Solomon has both with this court and with his peer district court judges. And those changes are essential in the establishment of his standing both under the Kansas Declaratory Judgment Act and regular
And
standing
you
issues.
pointed us to one case, the I'm not sure how to pronounce it.
Marichek
case versus McKinney, which is a Third Circuit case, which really was a concurring opinion that didn't actually survive in terms of the ultimate outcome of the case. Do you have any other cases that talk about a change in a legal relationship or an existing relationship satisfies the harm?
In our brief, we've provided the court with the authority that we were able to find, Your
And
Honor.
this is it?
This is it.
Okay.
Well, could you then maybe flesh that out a bit? Where's the imminent harm? Where's the apparent harm?
Well, the harm occurred on July the 1st, 2014.
So the harm was this passage of the statute?
The passage of the statute and the consequences to Judge Solomon as a result of the passage
I
of that
guess,
statute.
what are those consequences?
Well, first of all, the relationship that as chief that he enjoyed with this court, which is to say the fact that through his work with this court, he had developed a position of trust, a close relationship in working with this court. That no longer mattered in the selection process. What
Well,
mattered
that seems to be a lesser thing that he has to worry about then. He doesn't have to worry about something, it takes off something off the table.
Well, it does and it doesn't, because what replaces it is now a situation where the individual who is responsible, to whom he is responsible, or by the individual I'm referring to the court, is no longer the entity that determines whether he stays or not in the job. That status change places the authority on the peers in his district court judges. And that is a significant change in status, so that no longer are his actions simply based on what is in the best interest of the court. This changing status now also requires that he be concerned about how are these district court judges going to react to my best effort to administer the court. It creates a situation which is not healthy. It's not healthy for the court, for the Supreme Court. It's not healthy for the district court.
And that's the harm.
Well, that is the harm to him. It's personalized to him.
Does he have to state that he was going to seek the position again? I mean, he never does state that in the pleading or even in the app. Anywhere does he state he's going to seek the position?
No, but I don't think that's the issue. The fact is that as chief judge, the moment that House Bill 2338 became active on July 1st, 2014, the harm commenced.
And again, how, if he's not seeking the position, how does it harm him in completing his term?
No one's ever said he's not seeking the position. That's never been an issue.
Your point is just that the harm was immediate upon effective date of the statute.
Right.
That is correct.
And that's because the nature of his relationships changed, not only to this court, but to his fellow judges, who would be making the call, whether factionalism might develop, those sorts of things. You're saying that harm was immediate, it didn't have to wait until the next appointment date.
Absolutely.
Okay. I talked to your colleague a few minutes ago about the lines of analysis. And we discussed whether the kind of the straight-on constitutional language analysis is independent, or at least potentially independent of this four-factor test for separation of powers. I'd like to hear you address that. And, well, let's just leave it at that for now, if you would address that. Do you agree that there are two separate lines of analysis that may overlap, but are independent of one another?
I do, Your Honor.
Okay. And if you could just give me your, let's concentrate, if we may, on just the Constitution, straight up constitutional analysis, the language in the Constitution about general administrative authority.
The authority is found in Article 3, Section 1 of the Kansas Constitution, providing this court with the general authority to administer the courts in the state. So it is our position that by the passage and signing into law of House Bill 2338, that authority has been substantially interfered with. And as a result, the statute is unconstitutional.
Okay. Do you need Mitchell for that holding?
I think Mitchell is very supportive of
But do you
that.
need it? I mean, if we were to accept your opposing counsel's point that it was either dicta that can be disregarded or that it was just flat wrong, do we need it?
I don't think
to
you
get to
do.
your
No,
outcome?
you can make that determination without Mitchell. But to suggest that Mitchell is wrong, as was stated in the briefing by the appellant, to me is an erroneous position to take. Mitchell was decided by a court composed of Justice K. McFarland, Justice Hurd, who wrote the opinion, Justice Prager, Justice Lockett, Justice Holm, Justice Miller, and Justice Schroeder. And then they went through a careful analysis of what the meaning is of the separation of powers and the importance of protecting the independence of the Kansas judiciary. And to suggest that the capstone statement in the decision is mere dicta goes against the analysis, Justice Breyer, that you went through. The rubric of the case is what led the court to the conclusion that there was not a violation of the separation of powers. But clearly, if that same analysis is applied here, the answer would be quite different, that it is unconstitutional. Because in Mitchell, we are clearly warned that when a Supreme Court rule is in conflict with a statute, the Supreme Court rule must prevail.
But why did they have to talk about that? If there was no rule that conflicted with the statute, why did they have to talk about the rubric that would happen if there was a rule that conflicted with the statute?
Because
it seems to me like in that case, the question was answered before they even started the analysis.
But I think that the wisdom of Justice Hurd and the other justices in that decision was to give us a guiding light, to give us a framework with which to analyze issues that they clearly perceive may come down the road.
But isn't that a classic statement of dicta?
Well, there are, as the court is well aware of, two different types of dicta. There's judicial dicta, which is what I would suggest to you is, in fact, what we find in Mitchell, and this court has previously determined that dicta may be used as authority, and we cite those cases in our briefs. But it is incongruous once one reads Mitchell to suggest that the capstone is in fact the capstone statement regarding what trumps, whether it's a Supreme Court rule or a statute, is mere dicta. It is not. How could it be any other way? It is this court's determination of what is and is not constitutional that allows our democracy to operate. As an independent branch of government, it is your duty to make those determinations. And when a Supreme Court rule is challenged by a statute, such as House Bill 2338, and there is that significant conflict that has been created, the bill cannot survive constitutional challenge. I just don't know any other way that we can address that.
Moving back to the series of questions that Justice Stiegel asked you, if you agree that, as I understood your answers, you agreed that the legislature can establish the position of chief judge. In doing so, they also made a broad statement about what the function of that chief judge would be. In your mind, can they not only create the statute, or create the position, but define the position?
They have.
And is that constitutional?
I believe that it is, unless we end up in a situation where, by adding additional clauses, definitions, however we wish to describe it, they interfere with the court's administrative authority.
Well, what they said was something, without the exact language before us, that the chief judge will use the clerical and administrative power. Is that a delegation of this court's authority that the legislature has done?
Excellent question. I believe that the legislature does have the authority in the creation of the office to provide for certain functions, but this court has the authority to tell its administrator what functions it should perform. And that is precisely what we find in Supreme Court Rule 107.
Are there other questions?
One more question, or perhaps a series of questions. The 1972 amendments included a savings clause in Section 16, correct?
Yes.
Which, I'm not quoting it directly, but essentially says these amendments are not intended to overrule any then existing statute, right? And we've established that the then existing statutes do create the position of chief judge, and they do give administrative duties to that position. So as we read that savings clause together with the grant of general administrative authority to the Supreme Court, is that evidence that the intention of the drafters and adopters of the 1972 amendments actually intended that that general grant of administrative authority would not be exclusive, i.e. it would be a shared authority between the legislature and the court?
Well, and there have been many instances where there has been a sharing. A variety of issues demonstrate that.
So you're not here arguing that the administrative authority clause creates an exclusive grant of authority?
It does not.
Okay.
The exclusiveness is in the court's determination of cases and controversies. You make that determination as the Supreme Court, but in the administrative arena, it is the term exclusive is not in the constitutional amendment.
Right, the term exclusive isn't, but let me push you a little bit on that. It says the Supreme Court shall have general administrative authority. Even though the word exclusive isn't used, if another department of government takes a certain aspect of administrative authority, isn't it by necessity of logic true that the Supreme Court no longer has that aspect of administrative authority?
No, I fully agree. I was just answering directly the question as to whether or not the word exclusive
Right.
Was in Article 3, Section 1 as it relates to administrative function. But I believe that analogous to the word exclusive is shall have the authority to administer the courts. So if the Supreme Court has that duty, then clearly the court cannot be challenged on its determination as to how best to administer the courts, particularly when there's a rule as we have here.
It's hard to find analogous situations, and one of the points that Mr. McAllister made was that there is a statutory scheme in place for the United States Courts of Appeals, and that the chief judges are appointed or designated chiefs according to statute based on seniority. If, let's say there's a junior circuit court judge, perhaps my former colleague Nancy Moritz, says this isn't right, my prospects of ever becoming a chief judge are slim or none, I really want to become a chief judge. Could she challenge the statute and bring a successful cause of action based upon the Congress's intrusion on the Supreme Court's ability to decide that? And I know it's a hype, but isn't it the same question, really?
I don't think it's the same question.
Why not?
Well, because what we have in this situation is a Supreme Court rule, Rule 107, that has been employed for 40 years by this court to administer its unified court system.
So it's the existence of our current rule that's in place that makes the distinction?
Well, that and Article 3, Section 1, which grants this court the administrative authority. And there is absolutely not a single case or authority cited by the appellant to suggest that the legislature or the executive branch has administrative authority over the court system.
And one last question here too is how does the enactment of the statute impair the Supreme Court's administrative functions? The position's still there. There's a chief judge. The functions are outlined by the statute. How does the selection process impair our ability to administer the courts?
In many ways. First of all, as the administrator, the court should be permitted to choose the individual that, as your delegate, will administer the circuit or the district. Secondly, if there is dissatisfaction by the court not rising to a level of cause pursuant to 2338 Section 11, the court doesn't have the authority to replace that individual. And as was pointed out earlier in questions, suppose that the individual that the court deems not to have been appropriate for the position is removed, the district may send that individual right back. It creates a whole host of problems and potential problems that are disruptive to the appropriate administration of our judicial system.
The other difficulty about this case is kind of the ripeness aspect of the question, because we really don't know what's in place. Judge Solomon can actually benefit from this process. The length of the term is not designated by the statute. It could be that it's extended to a 4-year term instead of a 2-year term or a 3-year term. There could be other benefits that are derived from this. How is it that we know if he's harmed in any way, at least in terms of his position, and whether he will get the position and whether or not it's actually a more lucrative position in the sense of security?
Well, the issue of whether or not he will get the position is not as significant to Judge Solomon as the disruption in the relationship that has been caused by the changing process. That is what's at the crux of our case. There's no constitutional guarantee that Judge Solomon has a right to the position. There's no guarantee that he's going to be reassigned. But the question is that that's key in this case is that the relationship that he had with this court and with his peers has been inexorably altered by 2338. And it is our position that that change in status, that process gives him standing. If not Judge Solomon, then who? And if not now, when? That's the question before this court. And I like to go back to
So
something.
just, and this, you've gone back to the question that Justice Rosen, that change of relationship, I'm having a hard time equating that with harm. If you could just, I understand it's a change of relationship, I'll give you that. You have to curry favor with 2 or 3 or 15 district court judges, or promise one judge that you're not going to assign him to domestic if you vote for him. I think those are issues. But is it harm?
Of course it is.
How?
Well, for one thing, it's harmful to the administration of justice, which is
Okay, you go back to the...
which is his duty. It interferes with appropriate administration. It's as if he has a duty to this court to follow your mandate, but the judgment as to how well he's performing is by someone else. It creates a situation of uncertainty. It creates a situation where the best interest of both Judge Solomon as the administrative delegate from this court as chief, and also for this court as the administrator.
Well, this court's not the one that's bringing the lawsuit.
No, I understand, but this court is also directly affected in its administrative abilities when this type of situation is permitted to occur. So, I'm sorry?
No.
I thought you... So I'm just suggesting to the court that while it is true, Judge Solomon is the plaintiff in this case, the consequences are widespread if 2338 is allowed to survive.
Thank you.
Mr. Groninger, I had a conversation with your opposing counsel about what, if any, relevance the 2015 legislation has, and I mentioned the amici's arguments, and he had a response to that, and I'd just like to give you an opportunity to say whatever you'd like on that subject in response to what your opposing counsel had to say.
Thank you for the opportunity, Justice Beyer. I filed Judge Solomon's case on February the 18th, 2015. A declaratory judgment action in the Shawnee County District Court. The case was not decided until September of this year. However, in June of this year, in an act that defies logic, in an act that clearly demonstrates a total lack of respect for our separation of powers doctrine, in an act that demonstrates a total disregard for the Republican style of government mandated by the federal courts to the state, the Kansas legislature, at the direction of Senator Jeff King, passed House Bill 2005, a bill that sent a signal to the judge that was hearing my case, by the way, signed by the governor in June, telling Judge Hendricks that if Judge Solomon won his case, the entire judiciary budget was to be null and void for 2 years. That's outrageous.
Well, counsel, you're here arguing in favor of your client on the grounds of separation of powers, right?
I am.
One of the powers that's enumerated in our Constitution gives the legislature the power of appropriation.
It does, but not to destroy an independent branch
Well,
of government.
We may agree or we may not agree on
How
the
can-
wisdom of the legislation,
Well,
but you're attacking it on constitutional grounds, and I'm just asking you to square that circle for me.
To do what?
To square that circle, you're arguing that the legislature unconstitutionally violated separation of powers by invading the province of the judiciary, yet at the same time, you're arguing that the legislature had no power to do what the Constitution actually grants them the power to do. It enumerates the power of appropriation. And again, it's not a discussion about the wisdom of the legislature's choice. It's a question about whether or not they had the constitutional ability to make that choice.
Is your question based on the premise that legislative authority pursuant to our Constitution grants the legislature the power based upon Article 2 to do away with the budget's judiciary? Is that the premise of the question?
That's not no, that is not the premise of the
Well,
question.
if that's not the premise of the question, then how can anyone argue that legislative authority constitutionally granted under Article 3 allows one branch of government to do away with another?
That's not what's at stake here. What's at stake is a severability provision.
Well,
And I understand that you're linking those two very closely.
Well, but the
let's
2000
break that link.
I didn't link it. The legislature and the governor linked it by the passage of House Bill 2005. I didn't do that. The legislature and the governor voluntarily
Which
passed
contain-
into law.
It contains a severability provision, right?
Well, but that severability provision mandates the nullification of the budget of an independent branch of government.
And you're assuming that no one would ever come back and reappropriate money for the judiciary. I mean,
I don't have to make that assumption. My point is that the decision itself to pass 2005 was not only outrageous, but in violation of every constitutional principle.
Your position is that the doctrine of separation of powers does not, in fact, protect the legislature from doing what it did.
The separation of powers doctrine was not intended to have one branch of government eliminate the other. And that is, in fact, what House Bill 2005 does. It is an attempt to grab power by the executive and the legislature. It is an attempt to tell the court, either do it our way or your budget is destroyed. It is an attempt to control in order to gain a political advantage. It is wrong, it is unconstitutional, and in no case that I have ever read or found is there authority for the proposition that the legislature and the executive have that power.
So earlier I understood from some questions to Mr. McAllister that no party in this case is actually challenging Judge Hendrick's rule that the severability provision must be upheld and carried out. But it sounds like you're now arguing that those severability provisions are in fact unconstitutional.
We didn't address under 2338 the non-severability provision. That was not addressed by the lower court. But when asked about 2005,
fair enough. Yeah, and we did ask you that. I recognize that.
Right.
But your arguments are limited to the non-severability provision that's not even in front of us. Is that a fair characterization?
would you please repeat your
That
question?
the arguments, the discussion we're having right now, from your perspective, is limited to the non-severability clause that really is not in front of us because it's in the 2015 law.
Well, 2338 and 2005 are inexorably linked. And if we were to consider the four factors under the Sebelius, Morrison versus Sebelius case, one of the factors is what's the purpose? And clearly, one can make an argument that the purpose was simply not an effort to work amicably with the court to try to reach some sort of middle ground, but rather to impose its will on the judicial branch of government.
That kind of brings us back to where I was headed originally, and that was if there was anything you would like to contribute to the discussion of what relevance, if any, subsequent legislation has to the determination of the purpose behind the 2014 legislation. And if you think you've addressed that, great, but that was really where I was headed with my question, because I offered your colleague an opportunity to discuss it. I wanted to offer you one as well.
In the lower court, appellant argued that there was no pernicious intent, but that defies logic. If I have referred to 2005 as extortion on our courts. I don't have strong enough words to describe what it was like to be arguing a case before a district court judge, knowing that if that district court judge ruled in my favor, the judiciary's budget was to be canceled for 2 years. Did they not consider, when they were drafting 2005, the importance of our judiciary to our society? Criminal cases, civil actions, environmental law, all of the functions that this court performs on a daily basis. So I do believe that and I believe it's a third factor, if I recall correctly, on the four-prong analysis.
Purpose is the third, and your colleague's point was that the most recent jurisprudence from the U.S. Supreme Court indicates that a subsequent legislative activity has little, if any, relevance to determining purpose at the time. And then he and I had a little discussion about purposivism versus originalism or what have you in
Right.
constitutional jurisprudence. I was really just trying to get you to kind of focus on that one point. Would you agree with him that that seems to be the trend in the cases or not?
I would disagree that this type of legislative behavior should be considered irrelevant.
Okay.
But this really isn't totally subsequent legislation because it specifically referred back to the bill that's before us right now.
Absolutely,
So it
Your
was
Honor.
passed in the subsequent legislative session, but it was a subject matter included this statute.
And by the same legislative body. It's not as if there was a change in the legislative body and now we have a completely different set of individuals.
Are there further questions? Thank you, Counsel.
Thank you very much for your time.
Mr. McAllister, you reserve 5 minutes.
I'd like to start where my colleague ended. In fact, the timing was the first bill is spring of 2014, the second one is spring of 2015, but there is an election in between in the fall of 2014, so it is not exactly the same. But that's
So there was some change in
there was
personnel.
change.
Okay.
What I'd like to focus on in the rebuttal, 2 points. One is the standing question that's been raised, and the other is what I think this case really boils down to. On the standing, in response to Justice Rosen's questions, there is nothing in the pleadings about the theory that Justice Johnson articulated that we have to make a rule or do something extra. The entire theory, as I think is clear from my colleague's argument, is a change in the legal relationship. That really is the entire theory of standing on
But
which they rest.
standing is jurisdictional, and we have unlimited review of jurisdictional questions, and we often say that the district court was correct for a different reason. do we not?
Not in jurisdiction. I mean, usually when the court gets into subject matter jurisdiction, it's that nobody has challenged it and the court is finding that it doesn't exist. I'm not
Well, you
aware.
can't waive subject matter jurisdiction. It's not waivable. You can't acquiesce. You can't fail to raise the issue and grant subject matter jurisdiction if it doesn't exist.
True, but in this case, if it doesn't exist, they're arguing it does exist, and the only theory they have articulated is legal relationship. Even this morning, my colleague has not embraced your suggestion, so the only thing they've put into play is legal relationship, and if you look at that, at least using the U.S. Supreme Court as an analogy, it's crystal clear legal relationship gets you nowhere in terms of standing.
Can we go beyond the pleadings on that question?
I don't think you should. I understand Justice Johnson's point, but my sense, the only cases I can think of on subject matter jurisdiction are basically where the parties want the courts to decide and the court independently says, well, in fact, we don't have jurisdiction. I'm not aware of a case where parties are saying we don't have jurisdiction and the court says, well, we can think of a reason why we do. I mean, I just can't think of an example of that.
And okay, so then why is change in legal relationship not sufficient?
Because it opens the door to way too many plaintiffs and that you no longer get personalized harm. You get institutional claims. The most analogous case is Raines v. Byrd from the U.S. Supreme Court. Congress passes a line item veto act that says the president can now strike things out of our appropriations bills. People who oppose that, members of Congress, tried to file a lawsuit saying this is unconstitutional. The Supreme Court threw them out on their ear and said, you are basically just complaining about an institutional kind of injury. Yes, now your vote for appropriations bills is not perhaps as strong because the president may strike out items that you voted for. This is no different. I mean, when they can only find a Third Circuit concurring opinion that was not even consistent with the ultimate resolution of the case, there's just not precedent for legal relationship. I was thinking about this while sitting over here. The district court drew an analogy to the KNEA litigation that is pending, headed this way. The difference, arguably, and the state thinks there are standing issues there as well, but at least in the teacher context, they have been recognized as having a form of tenure or property interest after they get past probationary status. So changing the procedures, and I'm a teacher subject to that sort of thing too, a change in the procedures is much more tangible in that context than anything that's gone on here. And furthermore, if you say legal relationship change is sufficient for standing, there's just all sorts of possibilities. What if there's a statute that somehow affects the operation of universities? Now do we have students, faculty, staff complaining that the statute has changed our legal relationship to the state and to the university without being able to show how they're really harmed by the statute? So that's a very wide open door.
But we have case law that says that it's appropriate for public officials to obtain an authoritative interpretation of the law for the guidance of those officials in the administration of their public business. Why is this the same thing?
Well, if there's an actual case or controversy, Your Honor, I think that could be true, but here there's not unless and until something happens. I mean, I think of Morrison versus Sebelius, where it wasn't just that there was a law that said you need a judicial determination and someone had to challenge it to find out. The Attorney General was also directed to bring the case, and what the Attorney General said is that's what I'm directed to do, but I can't do that. I'm being told to do something unconstitutional, and that was very concrete, if you will, that if the Attorney General proceeded as the legislature asked, that would force the Attorney General to violate his duties and obligations. Here, there's no change like that.
Here there was a Supreme Court rule that directed Judge Solomon to notify the Supreme Court by November 30th whether he intended to seek reappointment. That date has come and gone, so that's not in the future. And we have a bill that was passed that conflicts with that. Back to what Justice Looker asked a long time ago, why isn't that a conundrum for him to resolve, that he could do so by seeking a declaratory judgment ruling on what do I do here? I have some things that I'm supposed to be doing now.
Well, again, Your Honor, you're creating his standing theory for him because he's not made any of those arguments. And notice to this court, he could still
I'm
give,
gonna
not
stop you
knowing
there,
what's going to
counsel, for a
happen.
moment. Why isn't that a change in relationships for him? Whether he's supposed to abide by that rule or not by November 30? Didn't that, I mean, isn't that encompassed in this changed my relations with the Supreme Court? They have a rule that tells me I have to do something by November 30th. Do I do it or don't I?
You certainly can make that argument that it is a change in duties. What I'm saying is he has never made such an argument. He's just saying the fact that I'm no longer going to be appointed by this court in and of itself is the change in legal relationship.
Let me read to you from the petition. Hold on one second. Just bear with me for a moment. I have to dig through here.
Well, she's looking for that. Page 22 of his brief says uncertainty and insecurity with respect to the process governing selection and retention of the chief judge. Isn't that what
Process,
we're
though. I
talking
mean, it's
about?
process, and again, there's no, he has no, as he is, I think, my colleague indicated, he has no entitlement to the position of chief judge.
Not to an outcome.
Not to an outcome, and no entitlement to any particular procedure. Whereas again, I come back to the teachers who have a form of tenure is arguably a very different situation.
I understand.
He doesn't have that kind of legal protection in the
But he has a
position.
duty. He has a duty to perform as chief judge, and this has created uncertainty in the performance of his duty. Does he give notice, or does he develop a district court rule as the statute says, or what? All of that has to be done before he's replaced, because there has to be a procedure for the election and a district court rule before his replacement, if he is replaced, is elected.
Well,
So
Your
there are
Honor-
certain things that have to be done either this way or that way, and why isn't that sufficient for him to have standing to say, how do I proceed?
Well, I have the sense that you are inclined to think it is sufficient, but if it's the uncertainty itself, that doesn't create standing. If there are obligations imposed, I understand your
The
argument.
language in the petition, I'll share it with you real quick so you can incorporate into what you're gonna say, it's just very general.
Exactly.
It says plaintiff's status, comma, and other legal relations. So that was my question. Doesn't that encompass, not only uncertainty, but just this, I have certain obligations under the rule. I have different obligations under the statute. Those are his
I don't
legal
think so, Your Honor.
relations.
Certainly, they've had the chance to brief it. They provided the affidavit the district court didn't look at. None of that says I'm being asked to promulgate a new rule. That's one of the burdens on me here. And I have to give
asked-
notice by November 30th. No, they've never raised that, even
It's
this
not,
morning.
certainly not that specific. We can
No,
agree
no,
on
it's a
that.
very general allegation. And what I'd like to say, because I know I'm out of time, is what I think this case boils down to, ultimately. If the court concludes there is standing and the matter is right, it's not the Mitchell test. It's the Morrison versus Sebelius factors, because the question is here, unlike Mitchell, we do have a rule and a statute that conflict. So in my view, there are two questions to be answered. Which one is valid and why? So does Rule 107 stand here? Does the statute stand here? So only one of them can be valid. We acknowledge they conflict. And the question is why, and we've had a lot of discussion, and I do think there are at least two ways the court can come at it. One, maybe first, is to try to define what the general administrative authority of this court is. Because if it does not include selecting chief justices, then there is cannot be any separation of powers issue. But even if there is general administrative authority, I come back to Justice Stiegel's point, nothing in Article 3 says it's exclusive, and there's a lot of evidence that it has not been viewed as exclusive, both prior to 1972 and following 1972. I would come back to, Article 2, Section 18, which is adopted in 1974. So after this amendment, again, indicating if offices, the provisions for election or appointment are not otherwise provided in the Constitution, the legislature has the power to provide for those by law. Chief judge position is not provided for in the Constitution. So even if 1972 in some sense trumped Article 15, Section 1, which goes back to the beginning of the state, Article 2, Section 18 essentially reiterates the legislature's power, as well as the savings clause that I think Justice Stegall mentioned. Again, no one thought in 1972 completely wiped out the legislature's ability to make regulations or pass statutes that would affect the courts. So at the end of the day, I would come back to, first, is this within the general administrative authority? If it's not, then I think that ends the case. But if it is, I don't think that ends the case. Then the court needs to go on to the question, well, is it a significant interference with the judicial power, and apply the Morrison versus Sebelius factors? Unless there are other questions, I'll conclude by requesting that you reverse the district court.
Other questions? Thank you, counsel. The court will take this matter into advisement and be in recess. Thank you.